Hi, welcome to the Special Needs Motherhood Podcast. And today I have the privilege of interviewing my mayor and an attorney that works with special needs parents a lot, Kristin Ishihara. And so I'm so excited that you're going to do this for us because this is very, very important information. And this is what I tell parents all the time. These things seem so far off.
They do.
But you blink and then here we are. And a lot of parents are scrambling when it's finally time to do these legal things like guardianship, special needs trust, estate planning, power of attorney, all that stuff. My encouragement to parents is always you do it like sooner than later.
Sure.
You just, first of all, we're not guaranteed a long life as much as we want that. But as a special needs parent, this is the thing that keeps us up at night.
Sure.
What will happen to my child when I'm not here?
Yeah.
And it's almost like an avoidance thing, I feel like, for a lot of us. Like, if I start working on it, then that means it becomes a reality. But this is just one of those hard things that we must talk about these things. We must be prepared. So I actually had a follower that said, would you do a podcast on these topics? And I said, I know exactly who to call. So I'm so just privileged to know Kristin. So let's just start. Let's go for it. Just dive right in.
Yeah, I would break those down into kind of two separate components when you're thinking about providing for a child, which is not necessarily different than a parent who needs to think about a minor child who might need things, but you need to think about it past turning 18 and how that applies and how that changes it. But you're still kind of thinking about, one, who would physically make sure that my children's needs are met, who would decide where they live, who would decide what their medical issues are, who would make sure healthcare is taking care of those things. And then you're talking about how to financially provide for that child and what that means. So if at 18 they apply for disability or Social Security, how does that become an income? And then how do they need to own other assets and those kind of things? So I would break those two things up.
Okay.
Which one you want to talk about first?
How about what happens to them? Like, who cares for them, makes those decisions?
Sure. So, of course, if you are a biological parent, until they're 18, you're caring for them whether they're a disabled individual or not, right? Mm-hmm. So that's the same for everybody. And in your will, you include who would physically make decisions. I usually say physically possess your child. So if I die, my kids are minors now. If I died and my husband died, my will says I appoint X person to be guardian of my child. For a disabled individual, you just continue that on. So if I have a disabled child who's under 18, same exact thing. If they're over 18, same exact thing. So I'm going to list who would be guardian of my child in the event that, let's just assume, me and my spouse are the biological parents of that child. My will is where I designate who I want to be guardian of that child in the event that I pass away and I can no longer do it. Mm-hmm. And then that guardian steps in just like you've been doing as a parent until they're 18, and they determine medical care, what doctors are seen, what medicines are provided, what any sort of healthcare stuff, as well as where that child is going to physically live. Mm-hmm. So then a lot of those things, hopefully you can talk to, you're going to ask and make sure that the guardian is agreeable, and then you can have that conversation with them. So does that mean they come and live in your home and provide that care? Does that mean your child goes and lives with them? Mm-hmm. Does that mean your child goes and lives in a supportive community? That's a conversation you have with that guardian so that they know your expectations. But then you're putting a trusted person in place that can do it.
Okay.
So the way you designate if I die is in your will that's correctly done. Now, the other thing to talk about there is what happens for you when your child turns 18. So until they're 18, you've been able to make medical decisions, you've done everything. So 18 is really where it gets scary. And so you need to probably talk, I would say, about a year in advance. You can do it as early as you want, but about a year in advance, start thinking about, is my child going to, when they turn 18, either sign financial and medical powers of attorney that because they're an adult now and they make adult decisions, regardless of what you and their doctor think, they are able to decide once they turn 18, they are the boss, they decide unless you do something that we're going to talk about here. Mm-hmm. So if they are able to make, I would say, usually good decisions, or maybe they would often agree with you if you made a suggestion. They're not disagreeable or not too vulnerable in other places of their life, that you might consider financial and medical powers of attorney. So with that, when your child turns 18, they would, in writing, designate, let's presume again, you and your spouse to be co-agents, where either one of you could make medical decisions, either one of you can make financial decisions for them, and then you'd list that same backup, probably that same person that would be their guardian if you passed away. But in that scenario, your child is the boss, and so if you disagree with them, child wins. So if child is somewhere and says, well, I've met someone and I want to get married, they get married, they do what they want. Yes. Any questions on that one?
Well, that was one of my thoughts, was what are the ramifications if you don't get that guardianship? Like, what are some of the risks, and what are some of the things that could happen? Is it harder to get it post 18, or, I mean...
Yep, good question. So you can get a guardianship at any time, and I'll talk through those steps in just a second. So sometimes people try powers of attorney and go to guardianship if it doesn't work the way they hope it will work. But a guardianship is not super fast. So that's kind of the risk, I guess, that you're weighing in doing that.
So what is the time typically?
I would say about 90 days, depending upon where you live. I'm answering mostly for like Gregg and surrounding counties. 90 days would be a good guess. The bigger the city, the longer you should expect it to take. Okay. But in East Texas, I think 90 days is probably a pretty good guess. But often how it comes up might be an emergency. So I know that that's the scariness of that. So the times when I've seen you, or you should think through it, would be if your child is vulnerable to other people. So, if they're living independently, that's amazing, but that might put them in the line of someone who might be trying to take advantage of them for whatever reason that might mean. So I've had individuals where they were the beneficiaries of a trust. And so they were, perhaps someone that another person would look at and say, oh, well, if I marry them, I'm a dependent, I can have access to trust funds or other things of that nature. They may not be vulnerable to anybody. If they're going to continue to live in your home, they're not going to have access to a lot of people who probably would try to harm them, so that may not be an issue. The other time that I think is important to just think through is how independent do they think from you? So if, as mom, you go to the doctor with them and they rely upon you and look to you to make a medical decision, then they're going to make the same decision that you've asked them to make, kind of, or advised them to make. But if they're going to be in that situation and say, no, I don't care what mom thinks or says, I'm going to decide what I'm going to decide, and that decision might not be in their best interest, then those are things that would make me say you might really want to consider a guardianship further.
Yeah. I have a question because both of my special needs kids are low functioning. So there's not going to be any like, oh, I don't want you to do that. It's like, it's on here. This is what we're doing. Right. And we love them. We have their best interest at heart. But what about people who have higher functioning individuals? So we have some friends and their daughter is higher functioning, and they were worried that there may be a downside to having guardianship. Like, let's say that she decides to go out and make some poor decisions. Like, what are they held liable for? Because right now they're allowing her to live in an apartment. Okay. But she does not show good judgment. She is ID but higher functioning. And so is there a downside to having guardianship, like in terms of liability for the parents?
There's really not.
Okay.
So guardianship does make you a fiduciary. So there's two types of guardianships. One is of the person, and that's the one I'm mostly talking about because I'm assuming your 18-year-old doesn't have any assets and needs a guardian of the estate, so I'm mostly going to talk about guardian of the person. But there are two types. So if you are guardian of the person, what your obligation is and what you've agreed to the court you will do is make sure that that person has the right care. And as long as they are medically cared for and living in a safe place, then you've met that fiduciary obligation. So if they make bad decisions, like in driving, that's not a liability that's going to come back on you in any way.
Okay. That's good to know, because I could not answer that question. I was wondering about that.
Yes. But let's talk about that process. So if you do want to be guardian, I would say we should talk about the pros and cons of that. The pros are you are clearly in charge. You clearly make all the medical decisions. If your child is in the hospital, you decide. You don't have to worry about any sort of misunderstanding with the healthcare team in an emergency type of situation. It's just real clear who does what. If that child is ever somewhere you need to get healthcare information about, maybe they have a stay in a behavioral hospital or other things. You don't get to decide in that situation because the state is doing it, but you get the healthcare information that you would otherwise not get. So it puts you at a higher level of making decisions and getting information, which, again, depending upon your personality, sometimes you just feel like you need for your child, and that's okay. I would say the negatives are it does certainly negatively impact their ability to live independently, I would say. So a lot of time, always, the guardianship will determine if they can drive a car, and that'll be based on the doctor's letter, if they can vote in a public election, and that'll be based on the doctor's letter, and if they can possess a firearm, and that'll be based on the doctor's letter. But most times, those rights are not included, and so that individual does not have those rights, and that's submitted to the state of Texas and kept on record. So you can carve those things out, but it does usually, not always, but usually remove their rights to do those things. So sometimes it can be an inhibitor for them living independently. The other thing that is ongoing is once you've become the guardian of your child, you have to file annual reports with the court. So the court is never out of your life once you've done a guardianship. You are always filing something with them every year to keep your letters of guardianship current.
So it's like you're almost reapplying? Is that what
it is? It is not intense. It's pretty easy when you are reapplying, but it does happen every year, and you've got to stay on top of it.
Okay. This may not be the time to ask this, but what does that cost if you use a private attorney? Are there other options? Are there like online options that you would or would not recommend? I'm sure that there are, I would assume.
There's really not.
There's not?
I do not think you can do a guardianship on your own in the state of Texas. I think you are really required to use a lawyer.
A private lawyer is the only route
you can renew on your own. That one's real easy. But to do the initial setup, I don't see any. I've never seen a pro bono or a pro se client be able to do that. Now, if funds are an issue, Lone Star Legal Aid, there are sometimes other avenues to get free legal assistance that you might be able to look into. But I do think you need a lawyer. Without question. For a minor guardianship, you would probably expect to spend around $4,000, I would guess.
Okay.
And that's not going to be true everywhere, of course, but that would be close to what our fee would be. It includes, so let's talk about the process. So if you came in and asked for a guardianship of the person for a child who is turning 18, you can start the legal proceeding 6 months before they turn 18.
Oh, that's good to know.
Yes, and to do the proceeding, you need an applicant who is going to be the guardian. That can be you as a parent, you and spouse as parents, but you can't have co-applicants unless they are married or they are both the biological parents of the child.
Okay.
So usually, if you're both parents, great, you can be co-guardians. If not, you're usually going to just have one guardian of the person. Just depends on your situation there. But you are the applicant. You hire the lawyer. You need to get a doctor's letter, or recently they changed it to allow, I brought my book in here so I'd say that right, an advanced practice registered nurse supervised by a Texas licensed physician to complete a medical certificate. It has specific things on it, so you need to get that form from a lawyer, and that needs to be done based on an exam within 4 months of when you file. So the earliest you could really start working on anything would be 10 months before your child turned 18, and that would be getting the doctor's certificate, and that certificate from the doctor has to be a Texas licensed physician or a advanced practice registered nurse serving under that doctor. We found that it was hard to get doctors to complete those. And so a lot of, whatever that is, PRNs would fill it out, and then it would be a whole lot easier to get those done.
Because it's time-consuming?
Yes. It's a 4-page document, but it is based on an exam. So the child has to be with that person, examined by them, all those completed, and then that's what proves to the court that they have a need for the guardianship. Okay. But the parent hires the lawyer prepares all the documents, review all that, of course, and submit that to the court. At that point, what's called a guardian ad litem, or attorney ad litem, is appointed for the child, the proposed ward. And that attorney has specialized training, so they have done many guardianships usually, but they come out and actually meet with you and meet with your child, and they're kind of the eyes and ears of the court. So they report back to the court, yep, they have a good house, they're going to do a good job, there's nothing fishy here. But then so all of the fees associated that are with, the court, your lawyer, the lawyer for your child. So it is not an inexpensive process.
So that's in addition to what they would pay the $4,000.
No, I think that's probably about total.
Total.
Mm-hmm.
Okay,
Yep, I think
that's good to know.
Yes.
What if nobody does this? What if what if you don't get guardianship and something happens to you? Like, does the state take guardianship of that person?
The state really never takes guardianship.
Okay.
So I would want to say, I hope to alleviate that concern. The state really is not in the business of wanting to be guardian of anyone.
Sure.
What is made a little easier, if you have done the initial guardianship setup, that is its own probate court proceeding that exists. So if you die, the person listed in your will just needs to step in and ask to be appointed the successor guardian. You've done all the hard work. So they just have to show up and say that to the court they're not a felon. They have to pass a criminal background check. That's part of how the process works. And then the court would appoint them. If you didn't have a guardian, then what happens is your will gets probated in its own proceeding. And then that person that you've designated to be the guardian has to go now start their guardianship proceeding to be listed as the guardian. Okay. So if you've done the guardianship up front, I would say it makes it a little easier for the person if you pass away to become the successor. So that's a positive, I suppose, as well.
Yeah. And so that day that you're going to go to court, are you, like, if someone hires you to do this for them,
you go with a lawyer.
You go with them, and for those who've maybe never been in a courtroom setting, I mean, we all have like these preconceived ideas from things we've seen on TV. Maybe you've never been in court. Like, is it an empty room? How long does it last? I mean, who else there?
Sure. It is a very easy. The judge is very nice. Everybody there has specialized training to do guardianships, so they've seen anything that could happen. Your child may or may not need to be there. That ad litem that comes out and visits with them will report back to the court whether they think it would benefit your child to be there or if perhaps it would be too confusing or actually harm them, in which case they can excuse their presence. Okay. So the child may or may not be there, but the lawyer that represents you is the applicant. The attorney ad litem that represents your child will come to court, will have already filed everything that needs to be filed, and so you might be on a docket with other people, so you might wait for a couple of minutes, but it'll be an uncontested prove-up, which just means you stand in front of the judge. You usually don't sit in like a witness stand or anything. Yeah. We just all stand in a line. You get asked about 5 minutes worth of questions that would be things you know off the top of your head. Can your child provide their own food, shelter, and clothing? Have you always provided that for them? What's their date of birth? Do you have any criminal background? Stuff that you would know obviously and immediately. So it is nothing to be scared of. The judge typically thanks you for what you're doing and says they're so glad you're there to provide for your child. So it is not anything to be scared of. Everybody's very nice.
That's awesome. So, like, what seals the deal? How do you know it's complete and it's done? You receive something in the mail, or is it done that day in court?
When you go to the hearing, the judge will sign the order making you the guardian of the person, and then following that, usually about a day later, you'll get from the clerk, upon request of your attorney, what are called letters of guardianship, and then that's what you give to doctor, education if they're in school, anybody that needs to know you're the guardian. You get letters of guardianship, certified copies, and you provide that to them.
And so then you start distributing them out to all those people. That's awesome.
Yep.
Let's see here. Looking down here if anything else. So that's the complete process. You went through that. Okay.
Yep.
So now let's talk about special needs trusts.
Sure. So if we stick with kind of the same hypothetical, disabled child that's turning 18, that's probably the time you're going to think about applying for Social Security or disability as well. And that's because when the child turns 18, now the resources of the household are not deemed to them. So a lot of times children can't be eligible because the household is counted against them as resources.
So they don't count any of the parents' resources.
Once
assets.
they turn 18, yes.
It's all what belongs to that person.
Which probably is nothing.
Okay.
Right. Yes.
Okay.
So once you're 18, that's the time to explore whether you might want to apply them for SSI is usually what it would be, because SSDI would be if they had some work history. But if they apply for that, Social Security has a separate process. So you go through their determination of disability, totally independent of anything we've talked about so far. If the child can receive funds directly, that means they'll have a bank account and the money will be paid into there. It's about $900 a month if they were eligible for the full amount. And you would want to be a joint owner on that bank account if it was coming to them so you could help them manage it. If the child absolutely cannot manage it, you can apply with Social Security to be what's called their rep payee, which means that Social Security would pay you, and you would have a special bank account set aside and designated for them, but they wouldn't be on it. Social Security sends that rep payee every year another report that they fill out, but it is totally independent of the guardianship process or any other special needs trust process we're about to talk about. But then the child probably doesn't have any assets in their name, and if they do receive SSI benefits, that makes them automatically eligible for Medicaid, which is a lot of times the reason that people want to do it, because Medicaid can pay for a lot of care if they've not previously been on that, or if they're aging out, getting off of a parent's insurance there. So Medicaid is usually the better benefit that you're looking for. But to keep SSI and Medicaid in Texas, the child that receives those benefits has to have less than $2,000 in their name. So when you think about what good a special needs trust could do, if me as a parent, and we never think about us passing away because we're always going to be there to provide for our kid, but when we pass away, we have to provide in your estate plan to not leave anything directly to that child. So how do you provide for that child if you can't leave things in their name? A special needs trust is the answer to that problem. So with a special needs trust, if you get online and Google this, I want to clear up that you're going to find two different types. One is what's called a first-party special needs trust, and that is the kind that you want to avoid. That kind is what someone can set up if they are under 65 and they end up with money in their name. So sometimes this is because you were in a car wreck and you got an award, but sometimes it's because your parents messed up and listed your name as a beneficiary on life insurance or other things. So if it comes into the child's name, they can do a first-party special needs trust and remain on benefits. But the reason that the state allows you to do that is whatever goes into the trust can be used for their lifetime, but at their death, that type of trust, a first-party trust, has a payback provision that goes to the state. So if there's money in that trust when they die, that anything that's been paid by the state for benefits,
they get reimbursed.
Is
that MERP? Is that what MERP is?
Yes, Medicaid Estate Recovery.
Okay.
Correct. So the first-party trust is where that happens. A third-party special needs trust does not have a payback provision.
Okay.
And so the distinction between those two is why it's super important that you use a lawyer that knows what they're doing and doesn't give you the wrong type of trust. But also just know that you can provide for your child and you get to say where it goes if there's money left in that trust when your child dies. So there is not a payback provision. So because I'm a third party, if I want to leave to my child money, I can put whatever restrictions on it I want. And so when I do that, it never comes into their name as long as I've designated it directly to go to that third-party special needs trust.
So I have a kind of a philosophical question here. So how does what's the government's attitude toward the third-party trust versus the first party? Like, it's because I know some people kind of have this almost like this conflict inside about like Medicaid, any sort of government-funded programs. I think a lot of us were raised to go, well, we don't want to be relying on the government,
Sure.
or it's a lazy thing to be on Medicaid, or it's almost a shameful thing, and like, oh, well, I owe them money, so I should pay them back. But what I feel like a lot of parents don't understand is that the government knows how to work around the rules, and they actually almost like bless it in a way, like they give tax loopholes, things like that.
Right.
I mean, to kind of guide where your money goes.
Correct.
It's a strategic thing that the government does. It's
Sure.
not like dishonest or anything. So
no.
maybe you can kind of like rest there.
Sure.
Maybe the conflict inside
I don't want
parents.
to speak for the government
Sure,
and why they
yeah.
set up those rules, but I think that in the way they set up Social Security in particular is that they realize that $900 is not going to pay all your bills every month.
Right.
So if I'm an individual on SSI, I'm going to have a real struggle paying for rent, food, everything else I need using what I've been given there. So the Special Needs Trust is a way that they have that SSI benefit to provide specifically for rent and for food.
Okay, that was another question. Do they audit that? Like, did they find out what you use that money for? Because if you're...
They can.
They
They
can,
don't
okay.
always, but they can. So the Special Needs Trust has very specific rules, and it's because the government is considering what one thing pays for over another.
Okay.
So they think SSI is going to pay for your food and your rent. That means that the Special Needs Trust can pay for anything else, but cannot distribute cash to the beneficiary, cannot pay for their rent, and cannot pay for their food.
Okay.
So the reason that they work together is because the government allows you to, through the trust, provide for other things that they're not providing for. So the special language is in a special needs trust, that trust is used to supplement but not supplant what governmental benefits are providing for. Okay. So you're leaving things to your child that would provide for any other medical care, that could pay for additional insurance premiums to make sure they have what they need, to pay for extraordinary medical care they might need, to pay for a car, for gas, for any transportation,
private
for internet,
day programs.
for phone. Yes, absolutely. Anything else can be covered by the trust, but they are intended to work together to be complementary.
Okay, that's really good. Keep going. Yeah. Sorry, let me stop you.
Yeah, no, so if I need to set that up in my estate plan, I have a couple of options on how I do it. I would say the easiest one is, let's say I'm married, I have 3 kids, one needs a special needs trust. My spouse and I would have wills that presumably, you get to decide, but presumably would say, if I die first, all goes to my spouse. When both of us die, split it equally between the kids, and John's share, who needs a special needs trust, will be in a special needs trust for his benefit, and you're going to choose the trustee that's going to manage it for him, because it cannot be John, the disabled individual himself, and you probably want to list at least a backup on there. And then in there, you'll designate where the funds go if there's money remaining in the trust when John dies, which often would be back to your other 2 kids, but it doesn't have to be. You can say whatever you want. So I would say that's the easiest way to do it. And then in the terms of the trust, or in your will, the terms of the trust exist. Because you don't probably need a trust set up now. As long as you're alive, you're going to provide for what your disabled child needs. So there is not necessarily a need to go set something up now and fund it. Sometimes people have other relatives that want to leave things to that trust. And if I've done that trust through my will, that trust does not exist at all until me and my spouse both die, and then that will is probated. So it may not be in time for someone, like if my mom wants to say, that trust is the beneficiary of her life insurance. That's not sufficient for her to list it. She needs an existing trust. So sometimes people will set up a trust now, and that trust would have you as the trustee, but your child as the beneficiary, using the correct terms, and then you'd list successor trustees that would take over. But then you'd actually have a trust name, a tax ID number that was different. So if grandma wanted to list that trust as a beneficiary, she would have what she would need, because she cannot list the disabled individual themselves and use their social.
You mentioned life insurance earlier, like, we put, this person on our life insurance. So that's something that people need to pay careful attention to with their life insurance.
You should,
because that cannot be undone.
Well, you can go back and change it anytime you realize it.
Yeah.
But you cannot list that disabled child's name on anything. Not a bank account, not an IRA, not a life insurance. It needs to be designated to go to their trust.
So is that an irrevocable thing? Like, let's say, worst case scenario, like something happened to me and my husband, and like Jude or Mabel were on the insurance plan. Can you, are there legal ways to go around pulling them?
If you're alive, you can go change it anytime. Once you've died, nope, irrevocable, and it gets paid to them, and now we got a problem.
Okay. Wow, that's super informative. Very, very. So how much does that process cost to get a trust set up?
Yeah, it depends what you do. I would say it ranges from $1,500 to $3,500, depending upon what you do there. The one thing I do want to mention that you can have in Texas, if someone has not included the correct type of trust in their will, maybe they didn't know, Texas law allows you to modify to add a special needs trust after someone has died.
Okay.
So like if your, grandmother had left a will that left everything to your disabled child, John, you can apply to the court to modify her will to make that a special needs trust for John.
Okay.
Where you really mess up is if you list that person as a beneficiary, because then the life insurance pays him, gives him a check, and all he can do with it is set up that first party trust that you would be paying back to the state at death for.
And it would all go back to the
right
to the state, because you rack up a lot of.
You'd end up trying to spend it all down, honestly.
Yeah.
Yeah, you just try and spend that trust during lifetime.
Okay. Wow, that's so interesting. So we talked about earlier about in the guardianship side was like transferring guardianship. So like I said, a lot of these things seem so far off, but like let's say I'm 70 years old and we're like, all right, like chances are getting higher and higher every day that we're not going to be here. So maybe we need to go ahead and like get all that in order, like who is going to be the guardian after we pass. Like, would there ever be a case where it'd be better to go ahead and pass off guardianship when you're alive. I mean, do you see that sometimes before people actually die?
Yep. Yes, so if you are at a point where you are needing help yourself because you're a senior, then you resign as the guardian and you support the next successor that gets appointed. And that's just like if you've already had it in place, it is very simple to add a successor guardian. They just have to qualify on their own and show the court they're a good person that should be appointed.
Yeah, and those are conversations that are good to have, when your children become adults and you start letting them weigh in on that. Like, do they want to take on that role? And that's something that I'm learning as I get older, like to not just assume that my other kids want to take on that role. They're kind of showing that they do now, but they're very young, so they don't have families of their own. But those are good conversations to start having with your adult children, and that they know and understand the results of that, of them becoming that guardian, and just having those, being candid and transparent now, because I don't know, the older I get and the further down this road I get, I see that people are just terribly unprepared and just almost living with this mentality like, I'm going to be here, I'm going to outlive my kid. And, it's interesting because, like, when you have a typical kid, you don't want to you don't want to outlive your child. But when you have a special needs kid, it's different. You almost do want to outlive them in a way, because it gives you a sense of closure and knowing that almost like you can die in peace. But these are ways that we can die in peace. It's just knowing that we have done we've dotted all the I's, we've crossed all the T's, and I just don't think you can start these things soon enough.
One thing that might change that I should have mentioned is you can designate different percentages. I gave the example of 3 equal shares between kids, but sometimes people designate all or more, or have a specific life insurance that's going to fund that, because that other component is worried probably about the financial aspect of you're gone, you're no longer providing, so making sure that there's enough financial in the trust for your child. So it doesn't have to be 3 equal shares. You could leave all of it to that special needs trust if that's what you want to do.
Yeah. Wow. So do you have any other things that we missed that we should cover?
The only other thing I'd mention is just an ABLE account. Okay. I don't know if you're familiar at all with those. Those are a complementary type of account to a 529 college account. So an ABLE account is an account that can be owned by the disabled individual, and it does not count as an asset. It has a payback provision. So we don't want to overuse the ABLE account, but if you have an individual who was determined disabled before age 26, they can open an ABLE account, manage it themselves, and they can have more than $2,000 in there because that asset doesn't count against them. So sometimes people have special needs trusts that fund an ABLE account that the disabled individual manages and can use for other things. So if that disabled individual has a Social Security account where their SSI goes, but they need more to help pay for rent or pay for food, that ABLE account can pay for both of those things.
Okay.
So sometimes you end up with an individual Social Security account, an ABLE account, and a special needs trust account that all kind of work together but don't break the rules, and you just need to know what to put in what and how to manage that.
And so do you help set that up, or is that something you do on your own?
Yeah, you just do that online.
Okay.
Yep.
So you just Google ABLE accounts.
Yep, you sure can.
Is there anything we need to look for scams, or like, there's just like, is it a .gov? Is it just a .com?
No, it'd be, if you Google it in Texas, I think it is Texas ABLE accounts. Each state has their own type of ABLE account.
And so is that with like a private bank, or is it?
Yep.
Okay.
Yep.
So, okay.
Yes. And you wouldn't really necessarily need to do that unless your child needed more for their monthly expenses. So you would not always end up with one, but it is a tool that you could use.
Yeah, another option there.
Yeah. The trust can own a house. I guess if you're thinking about where your child might live, the SSI can pay for rent and the trust can't pay for rent, but a special needs trust can own a home.
Okay.
So if you're thinking about how to provide for where your child might live, if it's going to be in the home can be specifically left to the trust for that to be, and then you'd be there living without needing to pay rent.
Here's a thought. So do y'all offer any sort of services where you just kind of check back in on people and make sure that they're doing everything correctly?
That they have it done correctly?
Yeah, because I'm just thinking, like, it's a lot to keep up with, a lot to
Of
remember.
moving pieces.
A lot to remember.
Nope,
I
really don't.
Maybe
Nope.
it's another side hustle you can throw into the mix of your busy schedule. So you can't keep more than $2,000 in an account. Who checks that? How do you know? Like, what if like 1 month you're like, oh no, we forgot to use the $500 for whatever, so that we could keep it under.
Yeah, Medicaid's an annual renewal, so you send that in annually. So if you mess up in the middle of the year, they probably aren't going to catch it. But you are looking for the last date of the month as it rolls to the first of the month. That is a specific day over midnight that it needs to be less than $2,000. So it can go up and down during the month.
Okay.
But on the last day of the month, have it below $2,000.
So if somebody has questions, like when they're preparing for that annual, could they pick up the phone? Who would they pick up the phone and call? Would they call y'all? Would they like for consulting?
Yeah, probably
guidance?
a lawyer. So the tricky thing about all of this is there's not good information out there. It does change a little bit, and the agencies that you're interacting with, they may give you legal advice, but they're not supposed to.
Okay.
And so you can't count on, like, if a worker says, well, you can do X, Y, Z, you call back, you get the next worker, you can't rely upon that advice.
Yeah.
So you really are personally responsible for making sure you get the right answer, which probably does mean you need to call a lawyer.
I have learned that so profoundly in my journey, because you start dealing with these agencies or, nonprofits or government run, whatever, and you just realize that person is just regurgitating everything that they were trained to say, and they really don't understand the complex system that Medicaid.
Well.
And I don't think it's intentional at all. It's just good to get to step back and just not take that as a final word.
Like,
always to do due diligence.
But not you. Yeah.
Right, yeah. Your situation's unique, and you just, I just have learned to do your homework.
Yep.
And ultimately, it falls on you. If it doesn't matter what so-and-so at the local authority or the State Board of Living Center or this insurance office said. It's that you've got to do your homework and just get on the phone. And some of my greatest resources are you guys, parents. A lot of y'all are more knowledgeable than doctors and lawyers and anybody I've ever met. Like, y'all have read up. And so have your people and get in some of those Facebook groups are really good of just bouncing off ideas. Hey, this is my scenario, and then getting good contacts and names of people you can call and talk to. Did you talk about power of attorney?
A little bit at the front, yeah. If you end up not doing a guardianship, every person over 18, so that includes you, that includes your spouse, that includes your child, disabled or not, once they've turned 18, they should have powers of attorney that appoint somebody in the event that they need someone to make a medical decision or handle financial assets.
Okay.
Yeah, and those are pretty easy. You can do those with a lawyer. You can also Google that and do that online.
Yeah, awesome. We cover it all?
I think we did.
Okay. Thank you so much. Y'all, I know this is so much to digest, but that's the beauty of YouTube. You can push that on replay and just keep listening to it and scroll back to the areas that maybe it was just too much. I mean, this is truly like drinking out of a fire hydrant, but don't give up. Just keep educating yourself. You surround yourself with people who are walking through this, people that are ahead of you, and we're going to get through this together, I promise. But thank you again, Kristin. And she's a great woman. I'm proud to call her our mayor, and just excited to see what you're going to do, especially for, our special needs community. I see some things on the horizon that I'm excited about.
Good.
All right.
Good. Thank you so much.
Thanks.